Good afternoon, everyone. I'd like to welcome you to WMU Cooley Law School for this presentation today. I am now going to turn it over to our presenters. Thank you very much for joining us.
Yay. Good afternoon, everyone. I'm Andy Shore. I'm the mayor here in Lansing. It's great to be here. Expungement is something that we've been dealing with for many years. I served in the legislature. It was an issue that I've always been interested in, the idea of getting things off people's records and making sure that they can be active and excellent members of society, making sure that something that one bad thing that happened many years ago doesn't affect people's lives forever. Again, it was always a policy issue. When I became mayor, I was approached to be a supporter of legislation going through the State House of Representatives. So I joined with the business community. As a city, we think it's really important for our citizens, especially here in Lansing. The business community thought it was tremendously important because they need workers and talent. And it turned out to be an incredible effort, a bipartisan effort to get the law changed to be a little bit more expansive. Now, I wish it would have gone a little bit further, but you don't always get what you want. But it was a great effort. And when you go from policy to practice, that's when things really get exciting. So we took it on immediately. Councilman Peter Spatafor in our last budget put some dollars in for expungement efforts. And then our city attorney's office took that head on. Amanda O'Boyle is here to my left, your right, and really they led the effort. They did just a great job. We had an event, a fair, not too long ago, and we had several hundred people coming through. We had more people than we could handle. Unfortunately, we didn't have enough attorneys to handle everybody, but it was still an incredible effort. Several hundred people were able to get in with attorneys, get through the very complicated process. And it's one of those things where you feel good about helping people. I know there have been several efforts. There was one over at Union Missionary Baptist Church a few years ago. And again, we're looking at whatever else we can do and in partnership with the college, with really everyone else in the community. So this is tremendously important for me and for our city, and I appreciate you all being here today.
I don't know how we want to handle this next part. Do you want to?
Ryan, you want to talk about?
Yeah,
Sure.
do you want to talk
That's
about
why
the
we're-
efforts, then we can go into the
Yeah.
procedural aspect of it.
Good for that. I'm Ryan Basor. I'm the president of the Great Lakes Expungement Network, and really thankful to all the attorneys, the city, the mayor, and Cooley Law for allowing us to do this. There's a saying that we hear all the time is if you do the crime, you do the time. There's another saying that's we paid your debt to society. That we really don't hear that much. And when you have a marijuana misdemeanor or felony, or DUI misdemeanor or felony, you don't pay your debt to society. I've been through it myself. And, inhibits things like jobs, college, loans, housing. But something that I even think about now, I'm a new dad. We have clients that come and they can't be on the PTA or they can't coach Little League. So it affects all aspects of life. So what we're doing is really important. And when we were working on MI Legalize and Prop 1, we always wanted to include automatic expungements. But we got told by people a lot smarter than us that if we did, that it would probably could be challenged in court, and we could put the whole act at risk. So we left it off begrudgingly. And thankfully, in 2019, as we all know, a bipartisan effort in Lansing that the Clean Slate Bill, Clean Slate Act passed. And that's when Josie called me up and asked me what we wanted to do. And what I wanted to do, I said I want to expunge as many records as we can. So with the help of Cobra Law, Paul Kalinda, and a lot of other activist attorneys, we got going. Last April, we started in 2 counties with 2 clients, and 11 months later, we're in all 83 counties. We've got over 1,000 clients, and we've expunged almost 400 records. So we feel like we're just getting our feet under us, and and just really getting going on it. So when, the DUI, bill passed and it was signed into law this time, we were excited because we have clients that can't get their marijuana record expunged because they have a DUI or impaired driving. So now these clients are going to be able to get both. And not to mention all the people, I've been getting messages since I posted about this online, just talking about, hey, I had a DUI 20 years ago, I've been drinking 5, it's still hanging around my neck, and thank you. So there's a lot of people, really excited about this. Like I said, I'm really thankful for everyone that's doing this and putting it on. Thank you, Josie, for doing so much of the hard work. And the way I look at it, just the education we're gonna get from Marissa and Paul today, and it's gonna be taped, is we're gonna have a spider web out of this, and over the years, this is gonna touch thousands of people's lives. So thank you very much.
So I'll introduce myself now. My name is Marissa Vinsky, and I am a criminal defense attorney at Chartier Nyapakuza, which is a law firm in Okemos. We practice throughout the state, but we focus solely on criminal defense, and especially since the new Clean Slate Act, we do a lot of work for expungements. I volunteered at multiple expungement fairs, and in the world of criminal defense, you don't get a lot of happy moments. Whether we win or lose, there's always like a difficult component of it, but with expungements, it's like every side is happy about what the end result is. I've been in court and received an expungement, and the whole courtroom has like burst out in applause, and the judge is so happy, and it's just a really good experience. So my goal is that as many people as possible take advantage of the new expungement laws. I feel like a lot of people in the community don't utilize them because, one, they either think it's too complicated and don't know how to do all of the steps. So I hope we're able to go through that today, but also they might just not know about it. So I think a lot with these expungement fairs, it gives citizens the opportunities to learn more about like the tools that they can use. So that's just a little bit about me. I don't know if we want to go, Paul, into the steps of how to basically do an application, and you can introduce yourself.
Yeah. I'm going to sit over here tonight, I believe, at some point, but thank you all for being here. I'm going to sit and watch.
Thank you very much. Hi, good afternoon. My name is Paul Talenda. I'm a Cooley grad, so I've been in these halls before, good and bad. I've been an attorney since, 2008 when I graduated from here. My practice has been criminal law and cannabis law. Unfortunately, cannabis law was criminal law for a long time, and now that it's just a regular old boring commodity, we're starting to see, let's say, real business happen. What I'm hoping to get through today is to share some secrets and some insight as to how to do this so you can advance your own cause and help others. The beautiful part about this act is it wasn't designed for attorneys, it was designed for people. So the forms have the ability for someone who, let's just say, can read the information and fill out the spots that
I
corresponds.
have one if you want to look at it.
We've got copies as well. It's something that you can walk through. And as law students, if you made it into law school, it means you can read. It means you can read the forms and fill it out. It really isn't a mystery. On the boring side of it, I'm going to walk you through the statutes and I'll reference the codes. The beautiful part of it is you just have to remember one number, and everything that falls inside of it is just within the sub numbers of the letters. So we're going to get into MCL 780.621, A, B, C, D, E, F, G, H, and I. But again, MCL 780.621 is essentially where all the setting aside of the convictions is couched. In terms of, so I can get my agenda, but in terms of what we're going to try to walk you through is the different aspects of setting aside a conviction as to marijuana misdemeanors, DUIs, regular misdemeanors, serious misdemeanors, single felonies, multiple felonies, and under the multiple felonies, the one bad night rule. With that too, I will, and most of this is practical as well, so I brought the forms. You can make copies of the forms. I've also brought my checklist, which is my cheat sheet, which is the clear way of saying where am I with this process, because as we'll hear, this process unfortunately isn't just mail it in and it get mailed back and there's a court date set for you. What we're finding is that the whole process from start to finish takes about 8 months. The worst part about that is you will, let's say, do nothing for 7 months and 25 days of those 8 months while you wait for the appropriate parties to respond. You correspond with the court and you establish the court date. And the other, let's say the worst part about it is you are dealing with different courts, different judges, which means that you are going to get a different answer for every phone call you call. Some courts are different across judges. Some courts are fairly universal judge to judge. But as we know about judges, when you control your kingdom, you get to make all the decisions, good or bad, right or wrong, sensible or not. Anybody from the prosecutor's office here? From the governmental side? Close enough. Okay, very good. Well, we've seen that with the city side, there's an appreciation of the way the statute is geared and is supposed to work and how it's designed to work and who it's designed to help. So one of the policy issues that you'll face when you have these, when you go to court in front of these judges, is that some of them might not remember that the law and the presumption of the law was changed to favor expungements and not to have the applicant prove their worthiness to the court. So if you get the sense, and we all know the difficult counties and the difficult judges who think they are more special than the rest, don't be afraid to remind the court of the court's purview in its decision making. So when they start to ask, well, what have you done since this event to make your life better and blah, 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 remind them that's the old rule. And I guess be polite about it as possible. Josie, you have a question?
But the judge is allowed to ask that question.
They absolutely are. And that's the whole bit, they can inquire.
The burden isn't in the statute, but the judge still can do whatever they want.
That's the unfortunate part, right?
That's the issue that we're having at the network.
Yeah.
Is
Yes.
that there's no unified.
Because expungements they're privileges, they're not rights. So I think with the word privilege, they seem, okay, you have to prove your worth because it's a privilege that you would get this set aside.
Yes. And that's where you're getting the problem with the AG's office. The AG's office will say, hey, this person may be statutorily eligible, but it's within the discretion of the court, which only, I believe, is only to not usurp the decision-making authority of the judges themselves. Sir?
As an attorney, in the expungements I've done before and after they changed, what you just said indicates that it's not advantageous to put before the judge the reasons why the expungement should be, why the record should be expunged. So that's what I typically do. I mean, regardless of the burden, and I always put out the reasons, why the record should be expunged. So I want to make sure that was clear.
Oh, no, absolutely. And that's part of the pitch, is to say, Your Honor, this person has made it so far, they are statutorily eligible, and then you get into the human side of it where it was like, well, he wants to take his kids fishing in Canada and can't cross the border, or he wants to go hunting with his grandkids, or those reasons of the limitation within the conviction itself will provide some motivation as to, I had a judge ask me this week, well, why do you want to get this off your record? As if not having
There
a
needs
criminal
to be a reason.
Right, as if not having a criminal record isn't good enough.
Yeah.
And so you get in those reasons where it's just like, well, geez, Your Honor, I want to be able to go participate in my child's PTA meetings. And that's more of a real aspect rather than just the
You don't want to be stigmatized by a criminal record.
Right, the ethereal concept of I've paid my debt to society and this shouldn't follow me around. I shouldn't be denied life insurance because I made an error when I was 19 years old. What I'll do just briefly for site and for source, and this will kind of create the foundation of what's going to happen in terms of the applications. 780.621 defines the process or who is eligible for and which offenses are eligible for expungement. So you have in the definition here is you have a person is convicted of one or more criminal offense, but not more than 3 total felony offenses, may apply to have all of his or her convictions to be set aside. An applicant may not have more than a total of 2 convictions for an assaultive crime set aside under this act during his lifetime. An applicant may not have more than 1 felony conviction at the same time for the same offense set aside under this section if the offense is punishable by more than 10 years of imprisonment.
And I don't want to interrupt you, but I have a nice handy worksheet that we can make copies of that lists the excludable offenses, the offenses that count as assaultive, so you can't have more than 2, and then the ones that are 10 years or more. So I have this on a PDF in my computer, so if a client is calling me and wants to consult, or if I have an iChat in front of me, I can just quick search this to make sure all my bases are covered. So this is really helpful too.
Yes. We'll make these copies available as well. Moving on to 621A, we're getting the definition of what a conviction is, which is important because you'll have people who say, hey, I got caught with pot when I was a kid, and I pled guilty and I went home. Do they have a 7411 or a HIDA or another status where it was a delayed or deferred sentence to where the conviction was not entered? Also, the most important part, the first thing you'll have your client do, or you'll do, is run the iChat, run the background check to see exactly what you are convicted of, how the convictions are listed under the state system, and then you have the court case number and all of your essentially application information within that iChat. That iChat will also give you the chronology of their offenses. Most people aren't lucky enough just to have 1 offense on their record. They have multiples, and typically they are compounding, where you'll have someone convicted of a marijuana offense or a drug crime, and their license would get suspended as a result, and then they get pulled over and get driving while license suspended, second, subsequent, thereon, so on and so forth. So they'll have a felony conviction that ultimately precipitates multiple misdemeanor convictions because of, let's call it practical reality. Your license is suspended, you need to get to work. Also, appropriately enough, 621A defines traffic offense as well, which is part of the misdemeanor system. Getting into, as we discussed, setting aside multiple criminal convictions arising out of the same transaction, this 1 bad night rule. This is the one for lawyers to navigate because there are restrictions in it. There are a lot of people that have a 1 bad night event where they walk away with 10 to 25 convictions. Those exceed the eligibility under this portion. But for 1 or more felony or more than 1 misdemeanor offenses, be treated as a single felony or a misdemeanor conviction if the felony convictions were contemporaneous, such that all the felony or misdemeanor offenses occurred within 24 hours and arose from the same transaction, provided that none of those felony or misdemeanor offenses constitute any of the following: A, an assaultive crime; B, a crime involving the use or possession of a dangerous weapon; C, a crime with a maximum penalty of 10 years or more imprisonment; D, a conviction for a crime that, if it had been obtained in the state, would be for an assaultive crime. So out-of-state, other assaultive conventions. And then, of course, dangerous weapon is also defined in the penal code. Now, the problem with this 1 bad night is that you're hearing it that, oh, that doesn't apply to my defendant who has multiple gun convictions or multiple assaultive convictions stemming from some type of armed robbery or gun transaction. And that's true. I have plenty of clients that come to me and say, I have, 4 assaultive cases and a gun case and the like. And in their situation, when they seek to have a true clean slate, eliminating 3 of 4 felonies isn't enough. So that's the conversation to have with a client, is to say, here's what we can do, and here's the limitation on what the result will be. Is it important to you to have 1 felony or no felonies? And is having 1 felony the same as having 10 in their mind, right? Because essentially, if we can't clear up the whole paper record, what do you do? And that's a conversation. That's from the client itself. I did one where a client said, thanks, it ain't worth it, because a felony is a felony. I had one client say, let's do what we can, because whatever part of my past I can leave behind, I'm good with. Please.
That actually relates me. My question is, with the law the way that it was before, if you exceeded the number of for what you are eligible for, like?
Yes,
Okay.
yes.
So it doesn't completely negate your ability to get things expunged.
Right, so if you have like the truly bad 24 hours that doesn't make you eligible, but the rest of your record would be eligible, well, then you're stuck with that at a point, right? As long as you don't exceed the 3 felonies, because now you can have as many misdemeanors as you want removed.
Okay.
To that too, we are seeing arguments for like for example, the AG checklist says, as for people who have not been convicted of.
Yes.
Now, the checklist isn't the law, I know that, but it is a very important tool for our DIY expungements, people that do it themselves. For people that have not, who have been convicted of no more than 2 assaultive crimes. What does that, no, I don't think it fits in the statute, I don't see that in the statute. But how does that reflect into the statute and into the law?
You have to look at what they were convicted of, what the actual convictions, how they're defined. Because the problem is, you'll see in these records where I was charged with A, B, and C, and then the case resolved with this conviction. So you have to look at what the actual convictions are, how those are individually eligible or not. Because you'll have certain cases that the assault cases might be pled down to things that aren't assaultive in nature or not with a weapon. Only now can we really gear plea deals in anticipation of expungements. Because before it was like, hey, you got 1 felony and that's it, you're still good. And if you add to that list, you're screwed. Whereas now it's, can we plead to A, B, and C because I know in 5 years I can get this all done versus, structuring a plea deal that doesn't make you eligible later on.
So strictly having an ineligible amount of felonies, like 5, does that make you ineligible from expunging the 3 that you can?
Correct, yes. It's essentially saying you have more, you can only eliminate what you would be eligible for and everything else remains. So just because you have all these things that aren't eligible doesn't mean that nothing else is. It just means that, here's this wart that you're stuck with. Everything else can be lanced off.
Just a practical tool for the one bad night. As an attorney or as people who are doing it themselves, in my experience, it's very beneficial to provide that evidence up front in your initial application. So I had a client who had 4 felonies, but 2 of them were use of a foreign transaction device, and they were within the 24-hour period, so that would count as 1. In my initial application, I put evidence and proof that that counted as one bad night, so that when I went to the hearing, the judge was already ready to make his ruling. The prosecutor didn't have an objection. The attorney general, they send their standard letters, so I actually had a phone call with John Pallas and explained, and he said, I'm totally cool with revising the letter, like I'll remove my objection. And he told me I'm one of the only attorneys he's seen who's been proactive for this and put forth proof ahead of time. And that will save people doing it themselves or attorneys a lot of time having to fight back and forth if you just put the proof up front. And I think the judges like that because it makes their jobs easier, like they have it right in front of them. It was at 30th right down the street, and the judge was like very grateful that he already had that in front of him to make his decision. So that's a practical tool that I would suggest. So in that case, I did a FOIA of his police record. There was like 90 pages, but I wanted to double check that there was not one mention of another date because his case was a little unique. The ROA was actually incorrect on the website, so it had the date of the offense for one offense 3 days before the other one. So according to the ROA, it was not within the 24-hour period, and he was adamant this happened literally like within 1 hour of each other. So we FOIA'd it, got all of his police records. Not one police report mentioned anything outside of the 24-hour period from the start of, even if they alleged conspiracy to the very end. It was all within 24 hours. So I attached police reports and for that case receipts because it was use of a foreign transaction device to show that it was within the 24-hour period.
Is there any drawback at all to putting all that stuff up front? Is Is there any reason not to do it at all?
It can't hurt you, and a lot of it is to avoid the problem that they try to make you look bad in court. I've had that situation where my client had a 27-year-old offense, and it happened in a high school parking lot, and it was like 5 years pre-Columbine. And the prosecutor said, oh no, this was an offense that occurred on school grounds, and it could have been so much worse, and geez, the whole world could have ended, and all that type of supposition. And of course the judge went along with it. And I told the judge, I'm like, well, first off, Judge, the AG says he's eligible by statute, so that says a lot. Secondly, and this is something that I'll bring up a lot, is that the 10-year rule, right, the 10-year gap, right, all the theory and all the principles behind why we don't go back more than 10 years in someone's criminal history and why we're not allowed to use that for habitual offenses and things like that have to do with, we agreed that you've paid your debt to society, we've agreed that your likelihood to repeat is gone based on that period of time. So they treated my client with, again, an almost a 30-year-old offense that he committed when he was 17 years old, as if he was going to go tomorrow to shoot up a high school. And while, let's just say procedurally I was in the right, emotionally I was the bad guy, and my client was the bad guy. So in situations like that where you can anticipate, and again, I'll maybe jump ahead here, but if your client is denied an application, they can't apply for another year. But if you are going through a situation where you can start to smell that this judge is going to be, let's say, is more concerned what the voters think of him than he is for justice, nip it in the bud, withdraw the petition. Because if the judge is going to say, oh, well, counselor, it seems like he's got this over here, and I'm going to put some problems in front of you that he hasn't shown true rehabilitation, I'll withdraw it and say, Your Honor, I'm going to withdraw the petition. I'm not going to give you the opportunity to deny it and make me come back next year. I'll withdraw the petition, correct it, and then see you in a month. Because now that I know what your complaints are, and now that I know what the real, let's say, non-legal issues are and non-statutory issues for his eligibility is, then I'll fix that and come back. And that's, again, controlling the situation rather than going there and losing and saying, sorry, we can't do anything for a year, even though the reason for denial is easy to correct or easy to address in advance.
Yeah, I was just going to say, I think it's huge about knowing your judge. So in my case, I knew the judge that we were in front of, and I knew, his position on things. And again, it wasn't like a school shooting situation. It was using a stolen credit card when my client was a teenager. So for that, I weighed the costs and, benefits, and that definitely was a benefit in that regard.
And that's the other side, too, is that let's say, predicting the advanced issues, right? So what you'll see on the AG letters for certain offenses is they are eligible, but you have to explore the fact of ineligibility, right? So 780.621C has to do with the applicability of which offenses can be set aside. So that ones that can't be set aside are a felony with a maximum punishment for life imprisonment, an attempted violation of certain sections of the penal code that we'll get into, and then following traffic offenses. Now, there's a rule that you can't have a traffic offense can't expunge a traffic offense that was committed if you had a chauffeur's license or commercial driver's license, or if the traffic offense causes injury or death. So when you have a client who has a driving on suspended and you petition to have that removed, the AG's office will respond and say, it appears you are statutorily eligible, but you have to inquire if any of these conditions occurred that would make you ineligible. I did one last week, and I started off by saying, Your Honor, this is a petition for setting aside a driving while suspended. I've explored the matter with my client. He did not have a commercial driver's license at the time, and the matter did not involve injury or death, so thereby he is statutorily eligible. So you nip it in the bud. You've essentially eliminated the questions to be asked by answering them in advance.
I think
Please.
it's wise to, as she has done, to get in as good as a light with the judge as soon as possible. That's only going to help your client and yourself. So anything you can put out to make the judge's life easier certainly would be beneficial to you.
One thing, too, is that if you can submit documents in advance to the prosecutor, and say, hey, this is what we're doing, it's just so you know, and especially in the more cantankerous prosecutor's office, and try to get that to the judge. Now, some of the hurdles is that when you're dealing with the standard forms, those standard forms are just fillable PDFs, and there isn't much of a place to explain yourself, which is good for the benefit of everybody else, but if you need to, if you're worried about that and adding the story in, it's an easy avenue to do so.
I think she had a question.
Yeah, please.
Does that mean that even if the traffic offense was committed while they were not in their capacity of utilizing their chauffeur's license or their commercial driving license, it still is not eligible?
That's the distinction. So my understanding is that it has to be the CDL for commercial purposes, and not just like I've got a CDL, but I got in a wreck on Saturday night.
Okay.
So it would be essentially on the job driving.
On the job, okay,
Yes.
thank you.
You know what? Let's do this.
Just a note about what Paul said about the standard forms. My office, in situations where there's something more that needs to be explained, for example, the one bad night, we'll just draft like a little small, we call petition to set aside. It looks like a standard brief that we just file with the scale form, and that way we could put like the exhibit for the documentation that I needed to put. So it's filed with the court. When we do proof of services, we send it to the AG, we send it to the prosecutor, MSP, and then the judge will get it as well. So we do sometimes draft extra documents in addition to the standard form.
That's a really good point. So we're lawyers. We're all really proud of our ability, and we think that if we don't spend 10 hours on one piece of paper, that's not worth it. Yes, the Supreme Court makes these forms available and fillable for you, and it makes it nice and easy. You can draft your own petitions if you want to. You have to meet the statutory requirements, which is within there, and it'll tell you what to do. But if you want to actually create your own pleading, because you want to add in all of the other details and really fatten it up, you can do that so it looks like a real classic pro proceeding that they would accept on one of the floors upstairs as an assignment.
Mm-hmm.
So you can do that. Don't be afraid, right? And sometimes when you have a more detailed client in terms of his criminal past, you might want to do that just to avoid having to educate the judge and prosecutor the details in advance. But that's all the way to do it is to just make sure that you are addressing this in advance so that you're eliminating the surprises. Because frankly, you're getting a lot of these judges that don't quite understand how a lot of this is supposed to work. And if you can advance and even make the petition to say, hey, this is why it's one bad night. It all occurred in 24 hours. All of these are eligible. So they don't have to actually think about it themselves. So what I want to do is that in terms of the next applicable statute down the line, 780.621D, actually gets into the forms themselves and describes the forms and the process that you go through. So what I'll do is switch to the form itself, and then I'll start with ultimately the main purpose, and this more streamlined one would be the marijuana expungement. So with the marijuana expungement, it's no longer a crime, right? This applies to marijuana misdemeanors that are no longer a crime. So what you'll see in the conviction portion of the ICHAT has to do with misdemeanor possession, marijuana, or its synthetic equivalents. Again, you won't see convictions under HIDA or 7411, which is where most of our first-time offenders and kids fall under. It applies to the primary and subsequent possession cases. So if you have a client, I just did one a few weeks ago where he had 3 different possession cases over 10 years. Those are outside of, let's say, the timeline for the other eligibilities. Submit the petition and get the paperwork back. So if you get a client that comes in and says, I've got 10 offenses, I've got 5 misdemeanors, 3 marijuana misdemeanors, and 2 felonies, is he eligible or not? He should be, depending on the felonies, depending on the time frame, depending on what ultimately the the chronology of what happened. So I've got, I'll walk you through the marijuana forms, and what I brought to is my marijuana checklist, so that when you are filing this, you know, you're not dealing with it like within a one-day situation. You're gonna have the client come in, they're gonna fill out the forms, you're gonna mail them out. It's gonna be like a message in a bottle. You're gonna throw it out in the water and sit there, and maybe somebody will respond to you. When you get the response, it'll be slow trickle. It is, the checklist just helps you keep a track of where you are. Because again, if the process is going to take 6 to 8 months, you know, you'll forget where this case is in 2 months when you get this file and say, oh, what happened? So in this one, you know, and I've got another one too for the regular expungements, but it'll tell you what to do. Get the copy of the conviction, mail it in, have the client sign it, mail it to the court, right? If there's a hearing, if they need a hearing, fill that out too. Mail the application to the prosecutor, file your proof of services. If they don't respond within 60 days or they don't object within 60 days, it would be deemed granted. So follow up on that. So again, you can have these as your first step, right? So the practical step is look at the totality of their iChat, pick out all the easy ones first, low-hanging fruit. Do all your marijuana applications first. Get them all done. The next part, and actually this is a good time to talk about a process that we discovered by bothering the AG's office. I guess we refer to as layering, and it's more of like the peeling back of multiple convictions over the years that aren't independently eligible in themselves. And that's a situation where you have a client who has a conviction every year for 5 years. Now, each conviction isn't eligible because the subsequent conviction cuts off its eligibility, right? Because you can't have you don't have a 5-year or 3-year period in between offenses. So practically speaking, what you'll have to do, and this is something that you'll adjust court by court, is you go backwards in time with each application. So my client that had offenses from 2007 to 2012, we went and had the 2012 offense removed. Next week, we're going back to have the 2011 offense removed. When that 2011 offense is removed, his 2010 felony becomes eligible. When that 2010 felony is removed, his 2009 misdemeanor becomes eligible. When that 2009 is removed, his 2008 felony becomes eligible. Now, if you're adding on 8 months to every process, that client might have a few years of getting to clean slate. But if you have a court or a situation where my client had 3 offenses over 3 years in the same court, depending on your judge, that judge might hear all of those at the same time. Mm-hmm. And it doesn't hurt to ask that, especially if it's like, hey, judge, this is a good court, you're a good judge, it's a busy place, my client has completely meaningless offenses, will you hear these all at once? They'll do it in Ypsilanti, they'll do it in Ann Arbor. In higher rent areas, they might not. Again, Oakland County on the east side of the state is notorious for challenging your right to justice. Let's start with the marijuana ones because that's the easiest, it's automatic. Yes?
So if somebody who has a conviction that's ineligible by the statutes and that has prior convictions, the ineligibility from that final conviction, I'm just assuming based on what you said, makes all of the previous convictions ineligible because of the waiting period.
You might get that interpretation from a lot of judges and prosecutors. The AG's office has taken it a step further and said that each offense is considered on its own. So if you have a situation where you have a 2019 conviction and the previous conviction was from 2010, the AG's position is that 2010 conviction would be eligible because that offense in and of itself cleared the eligibility period before you got the second offense.
So if somebody has a conviction that's ineligible in like 2015, and they have a prior conviction in 2013, that's within the waiting period. You understand what I'm asking?
Yes, in that situation, because it goes from 13 to 15, that 13 offense hasn't independently cleared its own requirement because it's not either 3 years or 5 years.
So if the 15 conviction is not eligible to be expunged,
Yes. Technically speaking, yes. Now, depending on which court.
I was gonna say know your judge, because in my experience, a lot of judges, if they're in your case, so it's 22 right now, there's been 7 years since that ineligible 2015, they'll still expunge the 2013 because there has been a waiting period, a 5 or 7 year period with no offenses. And I've seen prosecutors, some prosecutors' offices, Eaton County, they'll object, but the judge has ruled in my favor. Ingham County, they don't object, and the judges have ruled in our favor. So if there's, in the last, starting today, the last 7 to 5 years, or 5 to 7 years, no offense, I found that judges will consider that as an eligible waiting period. Yeah.
What does the AG say?
And in my cases, the AG has not objected in those
How
situations.
are you getting those letters back?
How quickly?
Yeah, it's
So,
like 8 months.
yeah, because it's based off MSP, because they won't respond until they have MSP's report. It's really interesting. I just filed my application, and, you know, some courts, they'll let you schedule a hearing right away. So we called the court, they let us schedule the hearing, and they're like, oh, it's a really small court that doesn't do many hearings. So they're like, how long are we supposed to wait? 60 days? And we laughed and we're like, no, that's not happening. So we set the hearing date for July. I don't know what MSP was doing that day, but they got out the report probably 3 weeks after we filed. So sometimes they're taking, they're doing it really quickly, and sometimes they're taking longer.
Well, and that's the thing, is I'm getting cases where I just got one that was mailed on February 18th. Like the stamp was February 18th. The letter date was January 27th. So it's like the old office where it's sitting on someone's desk.
They'll cash your check though.
Oh, for sure.
Because we've called and they're like, we ran your
That's the way we're
check.
tracking it, is
Yeah.
we'll see a
Yep.
cash check from the MSP
Mhm.
4 or 5 months before we ever see a letter from the AG's office. And in
Yeah.
West Michigan, nobody cares about those AG letters. They really care about those MSP things, and they need.
Well, actually, by the statute, you only need the MSP letter. You just need to give the opportunity and courts are kind of confused about that, and we've had to say you just need to give the AG an opportunity. If they haven't responded, that's on them, but all you need by the statute is the report. It's hard for a lot of judges to stomach, but.
That's the craziest part. So I'm in situations where, especially in the more rural courts, where the judges have been like, hey, she appears to be eligible, and there isn't anything that would give me reason otherwise, so it doesn't matter what the AG says because I'm looking at what they look at.
And that's what the AG's saying, right? The AG sends these incredibly vague things
Yep.
that says, as long as it fits this criteria. They're still not saying yes or no.
Right.
Right. They're essentially
They're
just
giving you a bunch of stuff to ask the client, right?
right. In reality, the AG's office is to give, ultimately to opine if not, right? If it's not a no, then it's a you appear to be eligible, which is just sort of the general language of it all. But yeah, figure out like in those dicey situations where you're not sure, sometimes it's worth it because there are some things with the AG's office, they're just like, hey, we're okay with that.
Yeah.
So that way, if the judge signs it, it's not going to get bounced back. And I'm going to jump ahead to the provision in the statute that says that if an expungement is improper or occurs improperly, it's just going to be bounced back and reinstated.
Reinstated meaning.
The conviction's
Whether it will
reinstated.
be granted?
So that, no, if the expungement's granted, and then it gets to the state, and the state says, this was improper, or you were ineligible, and the judge granted it without,
It doesn't matter because it's the judge's.
you're right,
opinion that matters.
it'll be reinstated.
Okay.
So that's the challenge, is like, hey, judge, if the AG hasn't responded, and they haven't said no, then grant it, because if you're wrong, they're just gonna reinstate it, and I'll see you when the AG responds, and if you're not wrong, we've sped up the process. But that's something that, I've had judges suggest that to me, and the prosecutor said no. I've had prosecutors suggest it, and the judge said no. I've suggested it, and they've both said no. So you're at the whim, but that's the other part, is that in terms of the court date and the scheduling, stay on them, because I've had situations where it's like, oh yeah, we're gonna give you a court date in 8 months, and they get the response in 2 months. Call them back and set up a new court date. Or tell the clerk to say, hey, give me a 3-month court date, and I'll call and.
We've done re-notices of hearings if we haven't gotten them in time and just gotten a new court date.
Yeah, and that's frankly the most burdensome part about it, is now you're doing just a whole new set of
Yeah.
mailings to say, it's not January 14th, it's March 14th.
Yep.
But don't let that discourage you, because again, once you kind of get an idea of how the court handles things on a ultimately universal basis or on the judge. So for instance, Wayne County, gigantic court system, so many cases. And they've stopped doing hearings on expungements because they said, hey, look, once you get the AG's response, you can just do a stipulated order with the prosecutor's office, and the judge will enter it. So essentially, upon approval from the AG's office, it's a green light. So they're not having you go through even the formalities of having a hearing, setting up the hearing. It's just submit a stipulated order and it'll enter.
That's awesome. When he told me that, I had no court I've experienced. I work mainly in this area, Ingham County, Eaton, Clinton, but I've done them in Muskegon, Paw Paw, Sheboygan, all these different areas, and that was the first time I heard about a stipulated order. I'm like, it's so efficient. If all parties agree, what are we doing here?
And it was their idea. That was the court's idea, because the court said, I don't have time to sit through a formality and put you on my docket when I have 100 other people on the docket. Just we can have the clerks do it after hours. Okay, so with the regular application for the expungement on it's the 227 form, SCAO form MC227. That is the application to set aside conviction. This is your general catch-all felony, misdemeanor, DUI application. I also have the checklist for the usual expungement process, because this one requires you to get a certified record of the conviction from the court, which will typically have you going down the rabbit hole of calling the clerk's office and then finding out how to obtain a certified copy and then how to pay for it. So in Wayne County, you send a request with a check and they mail it back to you. In other counties, you have to request it, they send you the form, and then you pay for it. Whatever the bureaucratic red tape is, as long as you get that certified copy, that's the most important part. Depending on the court, it's usually available online. They can email it to you or mail it to you. But just, again, call and figure out that process. But for the checklist, again, fill out the application, have it signed, have it notarized. Have the applicant bring a fingerprint card. The fingerprint card is proving to be one of the more odd hurdles, because the ink card fingerprint is usually available through your sheriff's office or through your police department. There are private companies that offer screening services that do those print cards that are usually walk-in and easier to do, but that I found is just based on where these offices are located. I've got one near my office. You can walk in, it's $20 for the fingerprint card, and it takes 10 minutes. Other places you have to advance and make an appointment.
So you don't have to go to a law enforcement agency to get fingerprints?
You don't have to. And the one thing that I'll encourage is that, yes, while all law enforcement agencies will offer it, it's the ink card that you're concerned about. And
59008.
yes, and a lot of places have moved to live scan, which is the FBI side. Google ink card fingerprints near me, and you'd be surprised at like that local place that does, urine testing also offers fingerprinting. You'll get the certified copies of conviction. You'll mail 5 copies of the application to the court and the clerk. Those are the applications that will be sent out to each individual party. AG's office, prosecutor's office, Michigan State Police, to the court, the original court filing, and then one for yourself.
For that step, I would check with your court first, because up here, for example, 30th Circuit Court, they'll give you a hearing date right away and won't require you to mail in all 5 copies, and you can fill out the notice of hearing, proof of service, and then serve them the same day that you file it with the court. So they won't make you mail in the 5 copies, but I know a lot of other, Eaton County will make you mail in the 5.
Yep.
They'll write the notice of hearing dates on it and send them back to you. So it all depends on what court you're in.
And the thing is, court by court, they'll tell you, do we get a date now or do we get a date later? And usually it's whatever the clerks want to do. Again, $50 check to the MSP when you mail in with the application. All the fingerprints and the whole packet. You mail the packet to the Attorney General's office, to the prosecutor's office. Fill out the proof of service to the court, right? Wait for your response, wait for your court date, wait for your application. The one thing I wanted to touch on, because this is something worth looking into is if you have a case and you're charged and you beat it, or you have a mistaken identity arrest where you're arrested and they find out that it wasn't you, or your case was ultimately just dismissed by the prosecutor because it was the right thing to do, they're supposed to destroy your fingerprints and destroy your arrest record, so that when they pull up your iChat, you don't have what they used to call a hippie arrest, where it was you have an arrest without a charge or a conviction segment. So it looks like you were just a protester that was swept off the street somewhere. So what they're supposed to do after 60 days is to destroy that biometric data so that your arrest record isn't there, so that they can't, again, treat you as if you were some prior offender. There is a form, MC 235, called Motion for Destruction of Biometric Data and Arrest Record. And this one says, hey, my case was dismissed, they didn't destroy my record like they're supposed to, so I'm asking you to destroy my record. This also parlays into the correction of the iChat. So I had a client that had an offense from like 1981. And when we went to get the certified copy of the conviction, we got a certified copy of dismissal. So this felony conviction has been on this guy's record for 41 years, and it was dismissed at court 41 years ago. So we sent him a copy to saying, hey, dear state, FYI, this is the right information. And you're just mailing it in to correct it. And the unfortunate part is that no one knew this until we got the certified copy.
I had the same issue. I had a client, she wanted to move to Canada she was sick and she needed to take care of her special needs daughter, and it was like a really touching story, and she applied to move to Canada, and the background check had this charge on there that she did not know about from the 80s, and so she needed help like getting that off, and it was way longer than it should have been for something that was ultimately dismissed. And a lot of the times, instead of filling out that form, we will wait the 60 days because the statute says if the prosecutor doesn't object within 60 days, it has to be destroyed. So we'll wait the 60 days, reach out to the prosecutor and say, look, you can't object, and then we'll do a stipend order, so we don't even need a hearing. That's in that case, the AG's office was like, what the heck? I don't know why that's still on there. So they were totally cool with it, but that is a good thing to bring up, definitely.
And also check too, because and have your clients check that record. I've had situations, courts change their name. So Frank Murphy Hall of Justice, Third Circuit Court, used to be called Detroit Recorder's Court, and they changed it, I think, in 1987. So I got a client that has two felony convictions out of Detroit, one from Recorder's Court, one from Frank Murphy, Third Circuit, same offense, same day. Same case number. So we had to go back and say, like, you know what? If you look at it, it's the exact same thing. You're just confusing the origin as if it were a different court, and it's not. And so these are, ministerial tasks that you have to go back and essentially motion to correct or send the information to correct. And there's actually, when you run the iChat, at the very bottom of the iChat, there's information as to what to do to how to correct it. Also, remember your clients that have just like your John Smith clients or your Bill Jones, and make sure that the Bill Jones that has the felony conviction is your Bill Jones, or make sure that your Bob Smith Jr. doesn't have a Bob Smith Sr. conviction on his record. Go through that, because you'll get clients, and it's very real. You ever been arrested? Yes. How many times? I don't know. You ever been to jail? Oh yeah. How many times? Oh, I don't know. It's very true. It's very true.
Yep.
And so you'll have to go through that and say, okay, 85, you got popped with cocaine. Oh yeah, totally. 1991, you got popped for armed robbery. That was me, right? 1997, drunk driving. Nope, no drunk drivings. So trust them, but verify, right? I got clients, you've been arrested? I don't know. Like, well, you'd know. Okay. But the thing is,
2004 was really hard.
Right.
Yeah.
Sometimes, and again, when you're dealing with, like, let's say, the craftiness of police technique, right? You could wind up in the police station without ever realizing what happened. You could end up in the back seat of a car under an investigation, and next thing you know, you get a court date.
This doesn't affect the driving record, though, correct?
That's a good point. So removing the traffic offenses doesn't affect the Secretary of State driving record.
Or drug offenses. offenses, right? Drug offenses are also on the driving record forever.
The drug convictions will show up on your driving record. So that's the problem, is that
Is it just convictions then?
it's the convictions.
So if I get my drug conviction expunged, it's not on my driving record?
The driving record will still maintain it from the time of the conviction.
Damn it.
But the penalty associated with the conviction will expire under the Secretary of State's own rules or by law. So your
So-
6-month driving suspension, right, you should be reinstated thereafter, as long as you don't have any subsequent DWLSs that then push out your eligibility for another year.
So I pull my client's master driving record. Let's say I expunge 2 misdemeanor cannabis convictions or something. I think those cannabis convictions are still on the master driving record.
They will be.
Is that true?
Master driving record, and that's the whole bit, is that the MCL code doesn't affect the record retention policies or the master driving record retention for the Secretary of State.
Even if you file the biomass?
All of it. So even me doing 45
Yeah.
miles an hour down a side street when I was 16 years old, it, like my very first, like I have 2 weeks to get my driver's license. If I go to Secretary of State, that's still there. I mean, I still do 45 down side streets, but you know, it was 25 years ago. But that's the problem, is that your master driving record look back will always include that information.
So that's, I think, a lot with now DUIs being able to be expunged. You really have to talk to the person about like what their goals are, because a lot of them don't realize that it will still be on their driving record. And yes, you can get it expunged, and that's awesome, and I totally advocate for that. It can help with apartments, jobs, all of that, but it will still be on your driving record. So I think that's really important for people to know, because like their goals a lot of the time are to impact their driving record.
Well, and that's the other twist too, is that, so you have a DUI and you're eligible after 5 years. So you eliminate the DUI from your criminal record, and then the following year you get a DUI. Now you have 2 within 7 years as considered by the Secretary of State. You're subject to their rules for 2 offenses in 7 years, which you can lose your license for a year. So that's what you have to explain to the clients, is to say, hey, look, you know, just because you get this off your record, you know, doesn't mean that there isn't some complications if you were to get another offense, right? As a, for instance, you get a client that gets 3 felonies expunged, goes out and celebrates and picks up another one.
Yeah.
Well, you're stuck with it, you know? So that's where you have to walk them through the parameters, because the impression is that it's like expungement follows conviction no matter what now, and you still have to be eligible and still have to work your way through the system.
Can you tell us a little bit about the burden when it comes to DUI expungement? So something I think we were all excited about was that the statute for regular standard expungements has no burden language, or at least it's not requiring you to come in and prove. But the DUI statute does. Can we talk about that a little?
Yeah, so
What
it
that means and how to get that?
it requires essentially that you, I don't like saying prove, but essentially prove that you have used resources and you've been rehabilitated and you've used, you know, the systems put in place for people who maybe are addicts or have alcoholism. You've used those tools and you've applied them to your life, and you're now at a place where you've been rehabilitated.
Do you think it mirrors the statute of what it used to look like, what it looked like 2 years ago for standard expungements, in terms of, hey, I am extraordinary in this way, I've invested myself in not only rehabilitation, but education, or my community is better because I'm in it?
I think this might be a harder burden, because judges, I think, look so like the stigma of a DUI and like how much it could impact the community. They really, really want to make sure that what they're doing is right. And so I think they might try to make people prove themselves 2 times more.
I agree. It's policy cases.
Yeah.
This idea that a lot of us have, which is, hey, they went through AA or whatever court mandated system they went through. Do you think that is enough? Or do you think we are setting our clients up for failure by telling them, don't worry, you went through AA, you signed your probation, whatever. Do you think we need to go further into that in terms of?
My answer would be it depends. I'm thinking the first thought in my head, a DUI from, let's say, 10 years ago. They were court ordered to do AA for a year, and you know, they had a substance abuse assessment, whatever. They did everything for a year. In those 9 years following, they haven't done anything to kind of show. And to me, in my eyes, you're living your life without any other issue. Like, to me, that shows that you can function. But to a judge, I don't know if they would be like, okay, you only did that year that was court ordered. In these 9 years, you haven't done anything else. Again, this is new, so I think we're learning how judges are going to look at it. But in my experience, that's kind of what I think is they might need that little extra push.
It's a context, right? So,
Mhm.
hey, I had 10 years ago, I had a DUI, and for a year I did this. And that year of training and education worked because now I have 9 years of showing that I've applied those things to my life, and it's displayed by the fact that I have no alcohol convictions or no other problems. So you use sort of like use the positive side where you can to show that it establishes, it's almost like you're proving a negative, right? You're saying, hey, look, this worked, and it works so well that no news is good news.
Yeah.
Is known, I guess, Mike, just a clarifying question, are these people expected to be extraordinary? Like, do they have to be?
Good story and eligible, right? So eligibility is number one because that's just a technical requirement, right?
Because that's my fear. I feel that everything else that I look at is very eligible or not, but I think the DUI stuff is not as cut and dry. I think it's really mostly up to the judge. And I want to be sure that I'm able to prepare the clients with a good standing when they go up there, right?
Yes, and I think the DUI, the distinction is the DUI requires more talking and more of a story.
Yep, I was just going to say that. If you prepare them, just as Paul said, to phrase it as, this 1 year of my life really impacted me, so that these 9 years following, I have not had any other issue. I haven't had a temptation to do this. It's just kind of telling them how to answer, because the judge is going to ask them questions. So kind of phrasing to them how to answer. I really like how you just explained all that.
And that's the other side too, is that when you get in the orders that you can send over, the order that you fill out, the orders essentially establish the criteria, right? That say, hey, the applicant has not been convicted of more than 3 felonies. There are not any criminal charges pending, right? The felony wasn't imprisoned by more than 10 years. The application is requesting the first violation, operating while intoxicated, be set aside. The applicant has or has not previously applied and had a first violation conviction set aside. So a lot of these things will, you start from the ending and say, hey, look, what makes me eligible? What's the good story? And it work from there. The other thing that I want to point out is when you print out the forms from the SAO, the very back page is the how-to. And I admit, I'll go back to this page and be like, did we do all this stuff? Yeah, is my checklist correct, right? And this is the best part, because this is what makes it accessible to the people. This is what it makes it, like, if you can read and fill out a form, this is how you can help, right? So, I mean, there's, again,
And it even gives you the addresses of who, like, where to mail it to the Michigan State Police and the Attorney General's office. So I look at that too. I'm like, what, did we do all this? Yeah, it's really helpful.
And then too, like on the forms, which was a change from some of the last ones, is that the signature side of the form is applicant. They used to say attorney. And some of them, they just say applicant. I'll cross it out and put attorney, and no one's going to give you a hard time because you're doing it on their behalf. So it is, it is fairly streamlined.
Just to clarify, you're saying you can sign the applications on behalf of your client
As an attorney, you can, yes. And that's where, if you have, Josie and I have talked about this, but if you have a situation where you've got a client who is in rural, middle of nowhere and can't get to you because they work 8 days a week, right? And, I've got 3 marijuana convictions and a DUI conviction. Okay, well, I don't need to see you in person to process that marijuana application because I don't need a signature, I don't need a fingerprint, I don't need a certified record. Just crank it out, mail it in. What I do need you for is when you get that DUI expunged, I need you to come in, fill out the form, give me the fingerprints, and do it that way. But even still, there are ways around that. I got a client moved to Las Vegas. So what did he do? Filled everything out, got his fingerprint card, and mailed it to me.
Yep, I have one in New Mexico right now. Just mailed it.
We're doing one in Texas.
Oh yeah, I have one in Texas.
Yes. The
and
uniform.
What happens is people are victim of poor and unjust policy here in a great state, and then they move out.
Yep, exactly right. But the ink card fingerprint, that ink card is universal. Because it used to be the FBI form, and that every state police agency had the same ink card because the government gave it to you. Now the ink card is a secondary intrastate form that we usually use to verify records because everything is ultimately shifted to live scan. So like you did live scan fingerprints for the bar, so did I. Everybody who gets a CPL gets live scan because that's the national fingerprint system. Whereas the ink card, you send the ink card to state police, ink card, they just stick it in the machine, they scan it and reference it and say, yeah, Bob Jones, okay.
So you guys are using you can use out-of-state ink fingerprint cards.
As
We
long-
had a client who lived half of the year in Africa because that's where he worked. So we called and tried to figure out like what card will be acceptable. And we ended up mailing him one, but it wasn't like the typical RI 0081. And they'll accept that.
But the thing is they work. It's the ink. It's the ink.
That
It's
was
the
at
print.
54B, Ingham County. Yeah, it's the ink is the.
It's the ink is the issue.
I've
And it-
had them reject it because the back of it isn't filled out completely. You know, like when you go and get it done,
Oh,
it says
yes.
like that this is for
What-
official use only, and so they're not supposed to fill those things out. But then the people that are doing it also won't do it, so I've had them be rejected at the court for
Really?
incomplete fingerprint.
Well, the fingerprint only goes to
It
MSP.
the state
Yeah.
police,
Yeah.
right?
Just the
So-
state police, yeah.
I don't know.
So they don't even, they shouldn't even get it. Because for them, I can see the court saying, no,
Right.
we don't
It's
take
a
blank
not-
documents or
yeah.
blank spaces. But the MSP, they, move it along. Okay, so,
Okay.
so you know what, the other side too, which is actually gonna happen, is that there's a provision in the set-aside language that creates the automatic set-aside that will occur, now it's
2023?
Yeah.
April 11th, 2023, which essentially says any minor offense, which is a misdemeanor, under 92 days and under $1,000, as long as 7 years has passed, that will the state will just wipe it from your record. So that's where, but again, that minor misdemeanor distinction, like offenses of under 92 days and under $1,000, those are typically like municipal offenses and city offenses and like, littering or public urination, just.
30-day trespass. things like
Yeah,
that,
just,
yeah.
board cop tickets,
Yeah.
right? Those, I guess in criminal defense experience, those make up a very small percentage of your criminal record. Because a lot of times you'll get there and it's like, oh, hey, you were berating a traffic cop or you're berating the meter maid or whatever it was, and we'll give you a delayed or deferred sentence of a what do they call it? Public, disturbing the peace, that kind of stuff. So, but that's where you'll get into the category of, when you look at the offenses, you'll see something and be like, oh, that's a oddly termed offense, or that's a weird code. That's when you start to get like you can't tie your alligator to a fire hydrant, it's a 90-day offense type of things. But look out for those things, because after April, or let's say starting April, you'll start to see, we don't have to worry about that, that'll come off automatically, this will come off automatically. So it'll give you, again, your client with 10 years of offenses, might give them some more relief.
We don't know anything about the automatic expungement yet, right? But what we do know is it's 2 felonies or up to. So do you think that, just given, I am cynical because I work with the state directly, do you think that the state will hold us to, as long as you weren't convicted of X amount of crimes, or do you think that they will let us just get what is eligible off automatically? Maybe I didn't.
No, and I'd love to think that they will just take the low-hanging fruit and say, like, here are the easy and obvious ones that are eligible, and we'll get rid of them. And anything with a question or anything with a, let's say, not straight answer, you'll have to petition for.
You don't think that they'll just say, no more than 3 felonies, this guy has 4 felonies, so he gets none off? You think they'll be?
They still would have to give you, again, on eligibility, give you those 3 out, right?
One thing I just want to touch on is high court misdemeanors, because a lot of my clients, it makes sense why they can't wrap their head around it. They were young. Their attorney was like, look, you're pleading down to a misdemeanor. You're good. So they pled to it, and on their record it says misdemeanor, but really it's a high court misdemeanor, meaning the punishment is more than a year. And so a lot of my clients are like, what? This is a misdemeanor. Why is it counted as a felony? So I think that's just something that's really important to note and make sure your clients are aware. I also have a list of high court misdemeanors, but in the statute, for expungement purposes, those are counted as felonies. So you'd have to wait a 5 or 7 year and not a 3 year if they think it's a non-serious misdemeanor, because they're considered a felony. Yes,
So if somebody has 3 felonies and 1 high court misdemeanor.
that would count as 4 felonies.
4 felonies, so they would be eligible for what exactly?
So according to the interpretation of the statute, they would be ineligible because they had more than 3 felonies.
Entirely ineligible?
Yes, so I have made this argument. I don't think a lot of judges will buy it, but my reading of the statute, I've made this argument that statutory construction, you should be allowed to have up to 3 felonies expunged, because the reading of it says you cannot have more than, or up to 3 felonies can have all of their convictions. If the word all wasn't in there, there'd be no point in that, because, you know, just don't include it, and then just people with not more than 3 felonies can't have anything expunged. So I've made that argument before. I was successful in one court, so they let my client get 3 felonies expunged, but he had more than 3. Yeah, so I let your client know that it's a gamble and you're not sure if at the end of the day it's statutory construction, but I briefed it. In my brief, I took out the word all and had it read as if there was not that word, and, you know, there's a bunch of case law saying like words or phrases can't be deemed nugatory, all of that. So I've made that argument, because I think expungements should be construed in favor of the defendant. Like, there's also case law that said the point of this statute is to be rehabilitative and, you know, help. So that's an argument I've made.
It was written very vaguely.
Yeah.
As far as eligibility.
Right.
For a point, yeah,
Yeah,
to
before.
make it more inclusive.
Yes, before it was straight up. You have one felony, 2 misdemeanors, any more than that, you are entirely ineligible. And now, that was my question earlier, is what are you eligible for if you are beyond that?
Yeah.
Are you ineligible or
I wanna
eligible for some things, but it sounds like you're saying you have an argument either way.
Yeah, because if you take out that word all is a qualifier. So if you have up to 3 felonies, if you have no more than 3, then you can have all of them. But if you have more than 3, you can get up to 3. That's a liberally construed reading of the statute. And again, it goes to statutory interpretation, but that's how I've argued it.
I was gonna say, in the paper side, so I just did one it was Monday of this week. It was a high court misdemeanor for maintaining a drug house.
Mm-hmm.
And I applied as a misdemeanor, as a 3-year misdemeanor, because the conviction said misdemeanor,
Mm-hmm.
and the statutory code wasn't one of the defined serious misdemeanors. So when I got the response back from the AG's office said, you appear to be eligible, and when the court
Oh,
went up
nice.
there, they treated it like a misdemeanor because it was qualified as a misdemeanor.
Mm-hmm.
So they said that, you know, and this is where the distinction is that the high court misdemeanor is punishable by more than a year, so the feds consider it a felony. So if you have a high court misdemeanor and you get a Fed case, they're going to consider you having a prior felony. And this is the part that is funny in Michigan, is that because we call it a misdemeanor, even though it functions as a felony, that part doesn't matter because it's called a misdemeanor. So that in terms of the application side, it appears that now the AG's office is saying, oh, if it says misdemeanor and it's not one of the enumerated serious misdemeanors, then it's a 3-year offense, not a 5-year offense.
That's good to know.
So that was with that part, but that was my client's only conviction. So that was actually, maybe I lied to you, so there is one more statutory code, MCL 780.811, which is the definition of your serious misdemeanor. So you'll see in the applications that it's more than 5 years have passed on a serious misdemeanor. The serious misdemeanors are defined here as assault and battery, including domestic violence, assault, infliction of serious injury, including aggravated domestic violence, breaking and entry or illegal entry, child abuse in the 4th degree, contributing to the delinquency of a minor or neglect, using the internet or computer to make prohibited communications, intentionally aiming a firearm without malice, discharge of a firearm intentionally aimed at a person, discharge of an intentionally aimed firearm resulting in injury, indecent exposure, stalking, injuring a worker in a work zone, and leaving the scene of a personal injury accident, and furnishing alcohol to someone under 21. So like those types of offenses, you'll see, and they're listed by the MCL code. So if you see the MCL code and that definition in your conviction category, you're out. Or I should say, that offense isn't eligible. And then you can get into the, like we talked about earlier, if that offense occurs in the middle of 2 other offenses, that one's not eligible, so should it be considered? It would be considered as a conviction and as a strike against the time frame of the preceding offense. But again, depending on the judge and the court, you might say, this is what we're doing, judge, and this is why. That one doesn't come off, but we're only concerned about these other ones.
What I've been noticing also is I think a lot of the local prosecutors' offices are more headstrong in fighting these than the AG. I think a lot of times, like in that case where you had your how you had maintaining a drug house marked as a 3-year misdemeanor, like I know prosecutors around here, they're going to be like, no, and they're going to object totally, but the AG was fine with it. So again, that goes back to knowing who you're dealing with and knowing the local prosecutors' offices, because I think they tend to fight more than the AGs.
And that they do. They've got this hill they want to die on because they have something to prove at every case, right? And this is such a, the conviction's entered. You got your prize.
Right. And my thing, even just I had an expungement last week where my client has done, again, you don't have to show this, but my client has done like phenomenal things since, and, statutorily, there wasn't even a question about if he was eligible. Like, there was nothing following the convictions we wanted to get expunged. Like, it was a very straightforward case. The prosecutor even said, like, it appears he's statutorily eligible, so I'll defer to the judge. Like, why can't you just say, I support the expungement? Like, it's just the phrasing. What is that going to do for you to say he's rehabilitated his life, he's paid for the crimes that he committed, and now he wants to move on? So I just thought that was so crazy. Like, what do you mean you defer to the judge? Like, he's eligible. So you stand your ground and say, yes, he's eligible. This should be expunged.
But they can't. That's
Yeah, they can't.
A lot of prosecutors can't
Yeah.
speak to the truth because it will backfire on their position. Say, you're not tough on crime. You conceded. You did all these things. So they have to, like you'll find in most cases, are you ready to proceed? Your Honor, we don't have a witness. So you're not ready to proceed. Well, we don't have a witness, Your Honor. So they're not saying the truth. They're just saying the first part and letting you fill in the rest, which is the same. It's the same point, is that you can't say you agree with the expungement because somehow that it throws the balance of justice out of whack, right? But that's, again, they're paid to defend a hill, good or bad. Anything else you want to go through?
No, I think are there any more questions?
Questions? Any?
I wanted some clarification on the one bad night thing.
Yeah.
Did you say that somebody would be, so if they were to get 2 felony charges in one night, and one of those carries a sentence of more than 10 years, it does not count for if they're not eligible for
that offense, yeah.
For that offense.
Wait,
So you,
everything else can be linked together except for that offense? Is that what you're saying?
So that would count as a felony, and say there's 5 other ones, those would all count as 1, 2. But you can't, so it wouldn't all be 1. You'd have 2 felonies at the end of the night.
I have a raid at my house, and there's like a felony methamphetamine charge of, let's say, maintaining a drug house, another felony, whatever, multiple felonies, like punishable by more than 10 years. I can combine everything else except for those ones that are ineligible. That's what you're saying? So if I have multiple felonies that can be combined and one that can't, I can still combine the other one.
so this is going to say that if there's one that's outside, it's going to take away the whole group, because it's going to say here, it says, for purposes of satisfying a conviction under section 1 or 1E, more than one felony offense or more than one misdemeanor offense must be treated as a single felony or misdemeanor conviction if the felony or misdemeanor convictions were contemporaneous, such that all the felony or misdemeanor offenses occur within 24 hours and arose from the same transaction, provided that none of those felony or misdemeanor offenses constitute any of the following: an assaultive crime, a crime involving use or possession of a dangerous weapon, a crime with a maximum penalty of 10 or more years imprisonment, a conviction for a crime that would be assaultive crime in this state, and
So they would all have to be looked at as individual.
yes.
felonies.
So that's where my client that shows up and, has the gun and the armed robbery and does those things, his whole night's out.
So you're saying that the 24-hour rule, based on what you just said, 24-hour rule, if one of the, say, 5 felonies from the one night has a 20-year sentence, that the other 4 can be expunged?
Other way, if you have the 120 year, it throws it makes you ineligible in
I
total.
thought that is contrary to what you just read,
In
though.
the 24 hours,
Yeah.
they're treated as one offense if they occur within 24 hours, provided none of those felony offenses constitute the following: an assault of crime, a crime, possession of dangerous weapon, crime with a maximum penalty of 10 or more years, or conviction of an assault of crime from a different state.
So I think the word none, like, because one of them does, it
It throws it out.
nixes it for all of them, because
Right,
none of
I
them.
just wanted to clarify
Yeah.
that.
Yeah, yeah.
I thought you had said that you could expunge the other 4, but not the 1.
The one makes it ineligible.
Exactly.
Yeah. So this is where it gets into, like I was thinking of you get a bunch of drug crimes and on the way home and you go home and strangle somebody. That strangulation is a 10-year offense, even though all the drug offenses are all 4-year offenses, 5-year offenses. So that one strangulation at the end of your bad night,
But could you make the argument that's not part of the same transaction?
that exactly right. Now, because the strangulation doesn't have anything to do with drugs, there's your argument. And the prosecutor's going to say, hey, no, it's 24 hours, right? So you're either applying under the 24-hour rule or you're not.
But drug offenses are the issue, right? Because they're not punishable they're punishable by 20 years. Here in Michigan, we have the toughest drug laws. So that's what we're seeing consistently when it comes to ineligibility, specifically for one bad night, is people with addiction problems never really get that shot, right?
Correct.
They don't come in and raid your house and hit you with one felony.
Correct. Because most possession offenses are under.
20 years, all of it, except for marijuana.
Well, and that's the thing. Possession of methamphetamine is a 10-year offense right out of the gate.
And we'll talk to legislators about it, and we'll be like, hey, this is preventing people from getting expungements, and they'll say things like, well, no one goes to jail for 20 years for their first methamphetamine.
It doesn't matter.
Yeah.
It's
Well, check out
fair, but
Lansing
they're still being
Court.
sentenced that way.
Yep.
The sentencing guidelines really do matter in post-conviction stuff and formerly incarcerated folks. And so I think that this narrative that we have in Michigan, that the drug policy reform or that drug policy is more relaxed here, is not true.
Well, and that's the thing, is because they're not making the exception within these qualified offenses to drug crimes.
Right.
So that you are still burdening the addict, as especially for the more seriously, I mean, heroin and cocaine and meth. It's there, so it makes it ineligible and treats them as if they were violent offenders. So it's still very prejudicial against the mental health and the addiction side of it, because you're still treating those people that, again, you got someone who's
You could expunge 2 assault crimes, right? You could literally punch somebody in the face, your neighbor in the face twice and expunge it. But
I could snort Adderall. I could snort Adderall, which is meth. And as long as it's not actually meth, that's only a 2-year offense, not a 10-year offense. So that essentially my result is the same. I'm still getting zooted off meth, but my economic status at the time of my arrest is different because guys in ties do pills, right? Not meth. And that's where we're getting to like the economically prejudicial, racially prejudicial.
And I don't see any way around it, right? So I don't see very many people with actual addiction issues that have a path to expungement, a clean, 100% clean,
Yeah, more
Right.
needs to be done.
And the reform is essentially like add 2 commas, and in between those commas put except drugs.
right,
Yeah.
which would be like what,
Right.
hiring and publishing maybe, and.
Right, because now
I
we're
can't
treating.
think of anything else that's already not restricted, that's punishable by more than 10 years that isn't a drug offense.
Also, they're crimes of violence anyway. Crimes of violence or
Right.
A RICO.
Right, that's exactly, all these things.
Yeah,
that are
uttering and
illegal
publishing
are
is the
already-
only, that's like not violent, but it's 14 years.
Right.
Yeah.
Uttering and publishing would be my only other thing that I can.
even criminal use of a telecommunications device as a
That's
felony is only a
4
4 or
years,
5-year
yeah.
offense, right? So like, that's the thing, is like there are tons of, let's say, emotional response crimes, right? I did this because I got heated and it's likely related to a domestic relationship or something like that. Those are more forgiving than the whole, I have an itch that I can't scratch. I'm huffing gas and glue in the car and I get popped with meth. right? That's a mental health issue, not a criminal issue.
Mm-hmm.
And it becomes a public safety issue.
For sure.
Right? This inability to get out of the system. And let's not forget that just because we're here doing expungements doesn't make us any less of an extension of that system, right?
For sure.
And I don't know if this is true for you, but clients never believe they're getting an expungement. Never.
Oh, every
Every
single
time
one,
the judge says
every
it's-
client I have, like, talks about how nervous they are
Yep.
to go to court because they associate court with bad things.
Yep.
And I'm like, I totally understand. This is, like, I want you to think of this as, like, a happy moment. Like, but it's hard to break that thought. Like, they're terrified to go in there because the last time they were in there, it was a terrible experience. And they were, you know, either they were subject to something that they really shouldn't have been, or they knew they should have been subject to that punishment, but they're not that same person. So it's a huge mental burden, I think, for them to, like, even want. I have a lot of clients also who didn't want to do the expungement because they don't want to relive that part of their life. But really, it's like separating that from who you are now. But yeah, it's hard.
They don't want to gamble again.
Yeah.
I mean, the client that I had to withdraw the petition because the judge had his head elsewhere, that conversation afterwards was terrible
Mhm.
because he was taking that as my life will never change and they'll always have it out for me. And the only thing I could respond to,
Statistically what he's seen, right?
statistically,
That's all it is. That's how all of his friends' lives are. and-
right. But the response I could give him was that, look, based on what the rules are, we're in a great spot because we've got this this guy in a black robe that can't see past his own nose. So we have to navigate around his shortcomings. But yeah, it's traumatic and it's problematic because, again, you go from people who don't trust the system
Mhm.
to now you have to be like, hey, we're going to go back in the system. It's going to be all set. But I had one client tell me, he's like, the only good thing about my felony conviction is I don't have to go to jury duty. I'm like,
I want to be called for a jury so bad.
I
I
know,
never
it's
will,
just-
but I want to. Yeah.
But that would, what I'll offer too is if, I don't know if how cooperative Cooley wants to be with their free copies, but if anybody wants copies of what we have, I'm more than happy to share this whole like little cheat sheet with the overview legislation on it.
Yeah.
I'm more than happy to share my checklists and the like. I will give.
And I can give these offenses if you want them.
And then I'll give you the numbers on the forms that you'll use, and just Google them; they'll come right up.
Mhm.
So the application to set aside conviction is, the original one is MC 227. The marijuana expungement is MC 227A.
And then the order's 228, I believe.
Yep, the order is 228, and the marijuana order is 228A. The motion to destroy biometric data and arrest record, if you need to, is MC 235. Once again, the statutory code for all the expungement is MCL 780621. I think it's A through I. And then the defined serious misdemeanors is 780811. 780.811. So those are the ones, that's going to be your foundational information. If anybody wants copies of the checklists or anything else that we have, don't be shy. Questions, comments, concerns, jokes? Anything?
Couple things. Always find it's wise to ask clients about convictions to show the iChat, see if there's anything that's not reported.
Mhm.
It's not happened to me, but I've heard of other attorneys where they show up in court and there's just something that's not on the iChat. So be sure to show the client the iChat. Make sure there's nothing missing. Also, even though you get an expungement, there are third-party websites on the internet that can have criminal records. So they apply for a job, the employer goes to the website, then they can see that it's still there, and
You know,
So,
say a lot of
Yeah.
times those are like weird, private websites and the like, and you can send them demands saying, this is, you're publishing false information, beware. Most
Those
of
are
them will
good
ignore it.
points.
Most of them will ignore it because it's like run by some guy in a lawn chair in Kyrgyzstan or something like that. But questions? Anybody want to walk through any models, anything like that? We can get, some hypotheticals or.
One thing that I've not done is easy at the live, but I think I may have one coming up, because I asked my insurance agent about the distinction, and he really didn't know, but, so the criminal aspect is removed from the criminal record, but the SOS, he retains a copy for lifetime.
Yes.
And there's no way to get that around that.
No, so as long as it's true, that's the problem with the master driving record. Like I said, I still got my first ticket from when I was 16 years old, because it's the lifespan of your driver's license. That is something to, review with the client, again, to say, is all this true, is all this correct, is this what you want to do? Because if the driving record is the limitation, right? If the driving record is what's holding them back, for instance, the guys that can't get certain driving jobs because of the DUI convictions, those aren't from their criminal record, those are from their driving record. So that's where, depending what the client's goal is, I think people call me like, oh, I can't get off my driving record. Well, it doesn't matter.
Right.
One thing we,
I'm sorry.
no, I talk all the time, you should talk.
Just, because I don't know, the driving record is kept by a state forever. I mean, say if I moved out of Michigan 40 years ago, you're still gonna have a record of that.
Yes, and it would end with the expiration of your driver's license. So it would say, driver's license expired, February 15th of 2022, status expired. So that even if you exist somewhere else, that license will, or that the master driving record will create the snapshot of your driving history in Michigan.
Something we didn't discuss, Paul, was enhanced sentences. So if somebody gets a double penalty, what does that mean specifically for like the one bad night, right? So if growing marijuana is a 7-year felony, but it's an enhanced double penalty, is it now a 14-year felony? How do I make that eligible? How do I do eligibility?
The understanding of it, as I reviewed this with John Pallas, was it's the underlying offense. So it's the offense in and of itself that you're concerned with in terms of the eligibility.
Not the habitual.
Not the habitual status, because the habitual status speaks to your prior offenses. So where you may have you're growing, right? It's a 4-year turn to an 8 or a 7-year turn to a 14. That's a function of your previous record that is also at play in consideration of your application. Because if you have too many habituals, that means you have too many felonies and you're ineligible. But you could be a HAB 3 and still be eligible because that's your 3rd felony. So it won't, the state, the AG won't treat that enhanced or markup as the criteria for eligibility in of itself.
Now, we're having issues filing some of these things with enhanced sentences attached. In terms of specifically for like Lapeer County, for example, who refuses to accept a misdemeanor marijuana form because it's got other things attached to that CFN, right? So I have a misdemeanor marijuana charge that's expungable, but I have other things that are not expungable attached to the CFN number. What do I do?
That's fine, because the marijuana is in and of itself, it's a loan, right? So
But they're not following that. I send them the invitation, I send them the application, I send them the instructions, I highlight in the statute that says, hey, here's the goddamn law, right? But what do I do when they don't care? And they're like, okay, but the CFN is this.
Jeez.
Right,
My first thought is to show cause them and to
Yeah.
say, here's, you can't, court, here are the rules, you can't do this. The proper
Is the judge denying it? I guess that's the question.
The court administrator's denying filing, it's not done correctly, they can't file it, right? Because they're not
Oh.
using the right form. Now, the
No,
administrator's filing is the problem, right? It's not filling out the form, it's not understanding the statute, it's getting the people that accept those to accept the filing. That is the problem. And if it was all unified, and this is the issue with us doing it in all 83 counties, is that we are some people's first expungement under the new law.
Yeah, for
I mean,
sure.
quite literally. And so what I'm having an issue with is getting places to follow their own rules. But what I'm finding out is that that's not an actual rule, right? They can administratively determine how they take these filings. Is that true?
But they have some governance over, there's rules about filings they can and can't accept. They can't deny legal filings on their own. It's that lady in Kentucky and the clerk, and she wouldn't sign the marriage licenses, right? You can't do that. Your job is to do your job.
But you can say, call me and get a court date, and then not answer your phone. Or say, you didn't give me a court date. You're like, yeah, dude, you told me to call you and give you a court date, and you didn't call me back.
Right, that's persistence too. So it's like stay on them. And I've had calls with, like, so if you get something from, like, I call it the desk clerk, right? Just Susie's working there and setting dates. She's the one that giving you a hard time. If you talk to the actual county clerk or the elected official, depending on where you are, and say, here's what I'm trying to do, here's what the statute says, and you're not letting me file it, tell me why. And if their reason is a real reason, that's something you can correct, because we're talking about a filing, right? You either check the box or you didn't.
Right.
If they give you this whole, because I don't believe in it,
You're not the judge.
that ain't
They
it,
do
right?
say that sometimes. They're like, I don't think you can get this expunged. And I'm like, well,
That's not up to you, right? So
Yeah,
then,
thanks for your-
in situations like that, then I would, especially if it's the clerk's office, that is saying, oh, I can't file this, show cause the clerk. Go to the judge and then show cause the clerk and be like, hey, I don't want to kick your ass. You are making me do this.
these are Paul's words.
You are not doing your job, right? If I have to sue you on mandamus and say, which is again the clerk in Kentucky, if I have to sue you and say your job is A and you are not doing A, I'm suing you to perform A. My feeling and experience has been is by the time Corporation Counsel gets that, there's a real serious talking to that says, you're making me bill the county for this when you are supposed to do your job.
That's true.
It-
So because of the sheer volume of things that we submit in the same county at one time, we're able to open a communication with a lot of these prosecutors
Yep.
to say, hey, do you know that you're wrong?
Right, and the beauty of it
And
too.
they don't. That's the thing. They really truthfully do not
And
know.
they're not supposed to believe they're wrong ever, because that's
Um,
not how you do it. But the issue, really, the beautiful part of it too, is that except for judges, everybody you're dealing with has a boss. So don't be afraid to play, old timey. And if you don't like person number one, you're gonna call back and ask for person number two. Or what I usually do is I Google their structure and I find out who's in charge, and I just call them directly. And then you just go, you start with the boss, especially if you have a problem where they're giving you an issue, and I call and say, I'm a lawyer, you're a building, you're here to perform an administrative function, and if you can't tell me the real reasons why I'm being shut out, there's real problems. Because everything, like your job is to tell me, that's a blank line, sign there, I can't accept the form without the proper receipt. You're exchanging cards at the point. They have zero ability to deny you going forward.
They have zero accountability in how quickly they respond to these, right? Except for misdemeanor marijuana stuff, which is not what I'm talking about.
Right.
Standard applications, I can apply today, and there's no, hey, you have to be in court in 6 years,
Yeah.
right? There's nothing. They can just play this game.
Well, that's when you
Um,
follow up on them, and that's when the requirement says this, requirement says that. And all of a sudden, in 60 days, we did it a couple weeks ago. It's been more than 60 days. You call them, and they're just like, oh, okay, thanks for reminding me.
Yeah, thanks for calling me.
Right.
I didn't know.
Hi, this is a new topic, and I think we touched on this briefly in the beginning, but the automatic expungement part that was in the statute is supposed to happen in, 2023 or something?
Yeah, April
Is that
23,
gonna be a thing? Or what?
That, you know what, I'm really curious, because to me, that says there's a system that's gonna read all these entries and say that once you recognize an eligibility, it'll pull it automatically.
Yeah.
I
I went to a seminar where the AG said they were building the technology to do just that.
would love
To
that.
do an automatic, which seems so unreal to me because they don't do that now. They can do.
But I view it as
But
imperfect.
that's what they were saying, is that that's what they're doing. That's why they're not gonna come out with the rules or the regulations or the way it looks until December of 2023, because there is so much technology to be built, and also a reminder that there's 2.5 million people with Michigan records here. Like, that is an outrageous number. There's only 10 million people in Michigan. That's 1 in 4. 1 in 4 of us have a criminal record. I don't want to point fingers.
No, but that's,
Implications of that going to be though, because, I mean, would you start from their earliest conviction and it would just start falling off, and then what of the rest of them? Do they suddenly become eligible because this person went from 4 felonies to 3 because of the automatic expungement?
it should be an at the time analysis, right? So that what'll happen is that as the sun starts to rise on your old records, right? That first offense was to become eliminated because it's been more than 7 years, right? As long as each offense meets the criteria of elimination. So you could have somebody, if the elimination requirement is 7 years and these types of things, you could have somebody with 3 offenses over 21, and then essentially as that calendar clicks, right, those offenses should fall off naturally. I would imagine that we'll see some of it happening, let's say automatically within the first year, and then you'll get a lot of people falling through the gaps, right? Like, hey, this should have been taken off 2 years ago.
Yep.
And it'll be the same thing as like why my client had a conviction on the iChat for a dismissed case from 41 years ago.
I just see it as such like this huge monumental task that they're saying that they're gonna do, and I don't I can't think in my mind of a way that they're gonna do this effectively. So I'm curious to see what will happen.
Right.
I tell my clients, like, if you really if you're adamant about getting this off, don't wait for automatic, just do it, because who knows what's gonna happen if they have the manpower, the technology to actually go through with it.
Well, and don't forget, there's always, reality of humans. I had a client left my office for his expungement out for, I think he was like 21 years old and was stealing stuff. And within a few days of that, picks up another felony offense because of a gun. So he's compromised his eligibility from, so many years of good behavior, but some of his practical reality caught up with him. Now we got problems. Because then it also says, well, now I can't check the box, I have no pending offenses, and it really screws up my calendar. So, yeah, don't wait.